application and appeal in the matter of 159 to 167 Prince of Wales Road, RTM Company and Assethold.
Yes.
I'm grateful, Nugee. At an early stage in his submissions yesterday, my learned friend very fairly acknowledged, and I quote, "My case is Benedictus. If you're not with me on that, I'm going to lose on the appeal," unquote. As we understand it, the principle that my learned friend seeks to derive from Benedictus is as follows. If the truth of some fact is an essential element of X's ability to make a claim, and X makes a claim asserting that fact to be true, then X is stopped from subsequently denying that it is true. That's what my learned friend submits is the Benedictus principle. And that submission, we would suggest, raises two separate questions for your ladyships and your lordship to decide. First of all, is there such a principle? Second, if there is it engaged on the facts of this case? And I will take those in turn, if I may. As for the first point, we say that Benedictus is not authority for the broad proposition that you cannot deny something that is an essential element of your claim, again to use my learned friend's words. There are three reasons why we say that, in addition to the points I made in opening, which I won't repeat. First, if Benedictus were authority for that principle, one might ask, where did it come from? My learned friends have not identified a single authority before Benedictus from which they say the principle derives. And yet in Benedictus itself, there is no indication that the court considered that it was formulating any new principle. Not only that, the only authority cited in Benedictus in relation to this point is the Dutton case, which we looked at yesterday. But Dutton is not and could not be authority for the principle my learned friend formulated, because it is not a case in which someone who brought a claim subsequently sought to deny an essential element of it. It was, on the contrary, a case in which the estoppel was set up against someone who had never brought any claim, namely Mr. Dutton's employer. So while we could have an argument about Benedictus, we couldn't about Dutton, because it, on the facts, couldn't be authority for the principle my learned friend seeks to derive. And that's the first of my...
Sorry, you
yes.
said the employer never brought a claim. I thought the employer was claiming back from the Secretary of State.
That's global elastic, man.
Oh, sorry.
This is the gas poisoning.
Yes, of course
yes,
it was.
but so that's why, that's the first reason why we submit. Benedictus could not be authority for the principle my learned friend cited it for. Second, it's in fact authority for a narrower proposition, albeit obiter. Namely that the issue of occupation under the Landlord and Tenant Act 1954 is non-jurisdictional and can therefore be the subject of an agreement or estoppel. That's what it's actually, albeit obiter, authority for. And the clearest indication that that's what Benedictus says is in the judgment of Lord Justice Bingham, Volume 1, tab 13, page 185. So about halfway down page 185, Lord Justice Bingham, as I pointed out yesterday, having initially been inclined to accept the tenant's argument, then referred to Dutton. And then over the page, at the top of 186, Lord Justice Bingham referred to the 4 examples, the hypothetical examples that we discussed yesterday, given by Lord Justice Atkin in Dutton. And then Lord Justice Bingham said, the question is therefore whether the agreement or estoppel contended for is one that operates within or outside the ambit of the Act. Pausing there, my ladies, my lord, having referred to Dutton, Lord Justice Bingham is framing the question that arises for determination in that case. But he doesn't frame it as whether you can deny something that is an essential element of your claim, which is what one would expect if it were authority for the principle my learned friend seeks to derive from it. Instead, the question framed by Lord Justice Bingham was whether the agreement or estoppel contended for operates within or outside the ambit of the Act. So that shows it was an attempt to apply the distinction in Dutton, not an attempt to formulate any new principle about not being allowed to deny an essential element of your claim.
How do you determine whether a fact which a claimant needs to establish is inside or outside an act conferring a limited jurisdiction on a tribunal? Do we have any better guide than what Lord Justice Atkin said in Dutton?
No, my lord, we don't. And I was making submissions about that yesterday, and I accepted yesterday and I accept now. It's a difficult distinction. Your lordship will recall we looked at an Australian case called Clark,
Yes.
where Chief Justice Jordan referred to a subsequent court of appeal authority called Rees and Imperial, which I've looked at. And Lord Justice Scruton says in that case, it's a very difficult distinction. What is within the ambit of an act and what is outside it? My submission, just to reiterate it very briefly, is that the true explanation lies not in any general principle of law, but in the particular wording of Section 1.3 of the Workmen's Compensation Act 1906. And the true principle...
Well, I understand entirely why Lord Justice Atkin said on the wording of the 1906 Act, the question whether you are an employer is within the Act, or
Yes.
whether you're a workman is within the Act, because the Act says so.
Exactly.
So it clearly confers on the tribunal jurisdiction to determine it. But in most cases, that's not how statutes work. Most cases say if a claimant can establish A, B, C, and D, they get a particular remedy. And sometimes A, B, C, and D are jurisdictional. So if they can't establish that, they can't even bring a claim at all. Sometimes they're non-jurisdictional, so you can bring a claim, but you'll fail. They're both facts you need to establish. I don't find it at all easy to determine
No,
where the line is to be drawn.
No, I respectfully agree, my lord. My submission is the line is to be drawn by reference to the distinction between substance and procedure. So if the relevant precondition, because as your lordship pointed out, in almost every statute, if it creates a statutory jurisdiction of some kind, it's going to say you've got to satisfy requirements A, B, C, and D. One of those might be procedural, let's say a time limit. The others might be substantive, because it might say something about the types of claim which may be determined by the tribunal, or the classes of persons who may invoke the jurisdiction.
But if that's right, why isn't the fact that you're a tenant occupying demised land for business purposes a jurisdictional question? But Lord Justice Bingham says that it isn't.
Well, and I respectfully agree with that, and that is the most difficult point in Benedictus. And if I need to say it, because it is obiter, it may well be that that was not the correct construction of the Landlord and Tenant Act 1954. But one difficulty about Benedictus is, as I pointed out yesterday, perhaps because it was an extempore judgment, the court's attention does not seem to have been drawn to the significance of 1.3. So the court may have treated Lord Justice Atkin not as expressing a view about the Act, but as formulating a general principle, in which case one gets into what I respectfully agree is a quite difficult distinction between substance and procedure. But just very quickly to remind ourselves, two authorities that put this in terms of substance and procedure, Lord Hodgson in the Essex County Council case yesterday refers to the fact that it would have been different had it been procedural. I think it's page 258. Second, Mr. Barnes QC, having reviewed all the authorities, including Cammins, puts it in terms of substance and procedure. And there is something to be said for that solution, because Of course, the distinction between substance and procedure could give rise to difficult questions, but it is a concept with which the law is familiar. It is used in other areas of the law. The conflict of laws is a good example, because questions of procedure governed by lex fori, questions of substance by the proper law, and one can think of other areas. It's a more satisfactory touchstone than to say, is it within or outside? Because in a way, without intending any disrespect, that just tends to beg the question how you work out whether it's within or outside the ambit of the Act. But what I do say, my lord, coming back to the principle my learned friend formulates, is whether Benedictus got it right or not as regards the characterization of the Landlord and Tenant Act, it is attempting to apply Dutton. It's not attempting to create some new principle.
Yes.
That was my second point. My third point is that if Benedictus were authority for the wider principle for which my learned friend contends, it would actually have surprising consequences and undermine other rules of law, both within the 2002 Act and outside it. As for the 2002 Act, my Lady Justice Falk asked my learned friend yesterday whether the issue of whether Assethold is a landlord is really comparable to the issue of whether the tenant was an occupation in Benedictus. Because if it isn't, then the Benedictus principle, even on my learned friend's formulation of it, isn't engaged. My learned friend's answer to that question was to say that it was only the negative counter notice we got from Assethold which allowed us to apply to the tribunal under section 84(3), and therefore the fact that they are a landlord is an essential element of our claim. But the difficulty about that submission is that there will be other cases under the 2002 Act in which more than one person who is served with a claim notice serves a counter notice. So let's take a simple example. Imagine I serve a claim notice on X and Y. X is actually a landlord. Y isn't, but I wrongly named them as a landlord and serve the claim notice on them. Both X and Y serve counter notices under section 84. In that example, X's counter notice is sufficient to enable me to apply under section 84(3). So in that case, it could not be said, even if I were to join Y to the FTT proceedings, that the Benedictus principle, even on my learned friend's formulation, if it is engaged, because the assertion that Y is a landlord is not an essential element of my claim. But if that's right, my ladies, my lord, then the consequence of accepting my learned friend's submission would be that the availability of the Benedictus estoppel would vary according to whether you have only one counter notice or more than one counter notice. If there's only one from the wrong landlord, as it were, then the Benedictus principle would be engaged, because it would be said naming that person as a landlord was essential to your ability to go to the FTT. But if there's more than one counter notice, the principle wouldn't be engaged. But that, with great respect, is not only an illogical, but an unprincipled distinction to draw, because it would make the availability of the estoppel turn on the happenstance of the number of counter notices. Put another way, if this estoppel is to exist at all, its purpose must lie in the intrinsic merits of the position as between the RTM company on the one hand and the wrong landlord on the other. It must be seeking to protect some interest of the wrong landlord. But the intrinsic merits of that position could not change just because the right landlord also happened to be served. But on my learned friend's analysis, that would be the consequence. And that is an indication in my submission that the argument is founded on an erroneous analysis of Benedictus. So that's the anomaly that would arise within the 2002 Act. But the problem isn't actually confined to the 2002 Act, because my learned friend does not dispute that in other areas of the law, what I sought to describe as the jurisdiction principle does exist. So for instance, he doesn't seek to cast any doubt on the outcome in, for instance, Dutton, Essex County Council, or Globalastic. And in any event, those are Court of Appeal or House of Lords authorities. So, if the Benedictus principle as formulated by my learned friend exists, that must be because there is something special about this particular fact pattern, namely asserting an essential element of a claim and then denying it, that differs from any other fact pattern that gives rise to an estoppel. For example, I ask rhetorically, if Mr. Dutton's employer was not estopped from denying that Mr. Dutton was a workman, despite having previously represented that he was, if Globe Elastic were not estopped from denying that Mr. Wijashko was continuously employed, despite having said they were, why is a tenant estopped from denying what it previously said, merely because what it said amounted to an essential element of a claim? There is no relevant distinction. They might be if you conceptualize this as abusive process, because that's to do with the conduct of litigation. But estoppel is not to do with the conduct of litigation. It is to do with what you say and whether somebody relies on it, whether it was reasonable to do so or not. So in relation to the first of the two questions that arise for determination in the light of my learned friend's submissions yesterday, we invite the court to hold that Benedictus is not authority for any principle that someone who brings a claim by asserting a fact essential to that claim is automatically stopped subsequently from denying it. There isn't any such principle. If I'm wrong about that, as I said a moment ago in response to what my Lord Justice Nugee put to me, and Benedictus is authority for such a principle, then we respectfully invite the court not to follow it. It's not binding because, as I pointed out yesterday, it's obiter, being an abusive process case. And to adopt the principle for which my learned friend contends would be a significant extension of the law, which is not supported either by principle or authority. So that's question one, as it were. But if the principle does exist and is good law, so if I'm wrong about my suggested answer to question one, we say that the principle is nonetheless not engaged on the facts of this case. Now, first of all, assuming the principle exists, it does matter whether it's classified as a form of estoppel or as a form of abusive process. Because and my Lord Justice Nugee put this to my learned friend yesterday, because estoppel, for instance, requires reliance, a representation, intention to rely, reasonableness of reliance, whereas abusive process does not. So it does matter. It's not just an exercise in taxonomy, it has substantive consequences. Now, if one analyzes Benedictus, the version of Benedictus my learned friend formulates, if one analyzes that as an estoppel, then the simplest reason why it's not engaged on the facts of our case is that there was no representation that Assethold is a landlord for the purposes of Section 88 alone. Your Ladyships and your Lordship have my submission why, in order to generate the estoppel, the only workable form of the estoppel, the narrow one, the only way to generate it is by reading down the representation actually made in box 3, which didn't say anything about costs, by reading it down to as if it said you are a landlord for cost purposes alone. But to do that would not only be contrary to the language of box 3, but also to the guidance given in the Northern Rock case, which my learned friend did not address. By contrast, on the facts of Benedictus, the tenant actually made a representation that it was an occupation. So there was no need to read anything down. Now, that's if it's estoppel. If, by contrast, one were to analyze this Benedictus principle as a form of abusive process, there's a different reason why it's not engaged on the facts of our case, one procedural and one substantive. The procedural reason is that Assethold did not take any point about abusive process below and can't take it in this court, not only because it's not in the respondent's notice and therefore not open, but also because abuse, by contrast to estoppel, would have given rise to additional questions of fact as to which evidence would have been required in the courts below. For example, about what each party knew. What each party knew, because knowledge, as I'm about to demonstrate, is an element of abuse, even though it's not, or arguably not, an estoppel. And that's actually the substantive reason. Leaving aside whether it's open, it's not a good point, abuse, because the requirements for this form of abuse are not satisfied. And those requirements are set out at the bottom of page 187 by Lord Justice Bingham. very helpfully in abstract terms by referring to Party A and Party B, as the court may recall. Bottom of 187, Lord Justice Bingham says, if in the course of litigation a party A accepts the truth of an assertion of fact expressly or impliedly made by his opposing party B, and founds on that fact formally to claim relief to which he would not be entitled if that fact were not true, and this is the important bit, A knowing if the fact is true or not, whether or not B knows, and if the litigation is thereafter conducted on the basis of the truth of that fact, A may not thereafter assert the falsity of that fact and retract his acceptance of its truth, etc. So that's the formulation of the abuse principle. But what's critical about that formulation is that knowledge is an ingredient of it. And one can see that if, as it were, we try and map the facts of first Benedictus and then our case onto Lord Justice Bingham's encapsulation of the principle. So Lord Justice Bingham's Party A and Party B would correspond on the facts of Benedictus to the tenant and the landlord respectively. So if we then look again at the proposition, so A, that is to say the tenant, accepted the truth of an assertion of fact made by B, namely
I
that...
don't think that is the right way to map it onto Benedictus. I think Lord Justice Bingham has in mind that Party A is the landlord who accepts the truth of the assertion by the tenant that the tenant is an occupation and founds on that to claim the relief in the form of interim rent.
Right. I had read it the other way around, my lord.
Well, sorry, I interrupted you. Tell us how you think
I read this.
It should be read.
Yes, so I read this as Party A referring to the tenant, partly because it's the tenant who would know whether the tenant is an occupation or not.
Well, it's also A may not thereafter assert the
Yes.
falsity of the fact. So
Yes.
the person is
Oh yes.
person prevented is
Yes.
A.
That's how I read it.
It is rather confusing though, because the first part
Yes.
Suggests that the assertion is by the landlord, which it wasn't.
The explanation for that may be that the landlord applied for interim rent. So the landlord's making an assertion the tenant is an occupation. But the tenant applied for new tenancy. So the tenant's also making the assertion.
Okay, so on your approach anyway, you say A is the tenant.
Yes.
And claims relief.
Yes. To which he would not be entitled if that fact were not true.
That's the new lease, is it?
Yeah.
And then you can't assert the falsity.
Yes, and indeed, just in support of that, over the page, the final element of the abuse is stated to be to deny B a remedy to which A's acceptance of that fact entitled him. I read that as a reference to interim rent. Because if you are in fact an occupation, then the landlord can say, Section 24 capital A applies, so I want interim rent, which tends also to suggest that A is referring to the tenant and B to the landlord. But I would accept the passage is not entirely easy, but I can make the point I was going to make in a different way, which is if one looks at what it is, leaving aside this passage, that gave rise to the abuse in this case, it is the fact that the tenant was not only seeking to deny what had been an essential element of its claim, it was seeking to do it in respect of a fact within its own knowledge. One can see why that is critical to the abuse. I come along to court, I say I am an occupation, I must know whether that's true or false, because I'm talking about me. I then turn around 3 years later and say, oh, actually I wasn't an occupation, therefore you can't have interim rent. But that is very different from our case, where, and indeed most cases under the 2002 Act, where the RTM company would not normally know whether the person to whom it sends the claim notice is a landlord. Indeed, even in this case, it was only disclosed in the pleadings that registration was pending. So at the point the claim notice is served, it is within the respondent or the putative landlord's knowledge, whether it's a landlord or not, and not the tenant. So the abuse argument, even if it were procedurally open, is not available on the present facts and usually wouldn't be available under the 2002 Act because of the importance of knowledge. So for those reasons, even if the Benedictus principle, as formulated by my learned friend, exists, we say it's not engaged on the facts of this case. That is all, subject to the court, I wanted to say about the Benedictus point, which in the end I think is what my appeal grounds are now boiling down to. I've only got a few other small reply points on my appeal before I turn to the respondent's notice.
Can I just before you leave that, I do think that I think Lord Justice Bingham may have mixed up his A and B's. I think he may have started off with the A being the landlord and B being the tenant, but I accept entirely that by the time he's got to the end of the sentence, A is the tenant and B is,
Yes.
B is the landlord. But your point is, it only makes sense when he says that if A knows if the fact is true, there it must be referring to the tenant, because it's the tenant's. Now, in our case, the fact of whether Assethold was registered as a proprietor is not something that's exclusively within Assethold's knowledge, because anybody can search the register and find out if it's been registered. And indeed, as I suggested at one point yesterday, the fact that it also sent a notice to whatever the other company was called.
Millcastle, yeah.
Thank you, Millcastle, suggests that it had searched the register and found out that Millcastle was still the registered proprietor. And then in the response, Assethold explained what the position is, which is that they bought it in 2019, but it hadn't yet been registered. So if it's a question of knowledge, why are those facts not sufficient to give the tenant sufficient knowledge of what the true position is?
Yes, I see what your lordship is putting to me. So 2 points on that, if I may. First of all, and here there's a link between the appeal grounds and the respondent's notice. If Assethold's case is that it's a landlord by virtue only if it's alleged equitable interest, that's not a fact within the RTM company's knowledge because it wouldn't show up in the land registry.
Yes.
So to that extent, the abuse argument doesn't work.
But they only need the abuse argument. Being an equitable landlord's not enough.
Yes, I see that. Yes, I see that. In which case, my answer is twofold. First of all, it's true, as your lordship says, that anyone can go and look at the land registry. And that, I accept it's true, means that this is not a fact exclusively within the respondent's knowledge, but nor is it a fact exclusively within the claimant or the RTM company's knowledge, whereas in Benedictus, what I would submit gave rise to the abuse, what was particularly unattractive about the tenant's conduct was that it was seeking to go back on something that was exclusively within its knowledge. Who is in occupation of your premises? If both parties are in the same position, as good a position as each other, which at a minimum they are, in the example your lordship is putting to me, it's less obvious why there should be an abuse, or at a minimum, so to hold would involve extending Benedictus, which I respectfully submit should not be done.
Yeah.
And I'm going to come on and make some submissions about the facts when I get to the respondent's notice, about why the position was in fact unclear, but on Benedictus, that's my response. Turning then very quickly to some miscellaneous points on the appeal grounds, intention to rely, reasonableness of reliance, and actual reliance, they are obviously separate requirements which must be satisfied, even if I'm wrong about issues 1 and 2. In the context of actual reliance, my learned friend referred to the Mayhew case, which I'll deal with very briefly in a moment, but I don't think he addressed intention to rely or reasonableness of reliance, which are also requirements that must be satisfied. As for actual reliance, the simple point here is that there was no evidence of it. And the Mayhew case, unsurprisingly, does not say that such evidence is not required. I hope the court will forgive me if I just give a reference in view of the time, but at volume 1, tab 21, page 279 of that judgment, there is a factual finding that the landlord relied on the representation by refraining from serving a further notice which it could have done had the representation not been made. So it's a textbook case of a reliance on a representation by the representee because it was induced to refrain from doing something which would have improved its position by the representation. But in this case, it could not be suggested, we would submit, that the reason why Assethold chose to participate in these proceedings is that it had been named in box 3 as a landlord. Because going back to the discussion my learned friend had with my Lord Justice Nugee yesterday, where the 4 options were identified, what could have been done. Imagine that the claim notice had said something like, we are not sure whether you Assethold are a landlord, but we know landlords take every conceivable point to defeat our claim. So we're going to send you this claim notice so that if it should turn out you're a landlord, we don't have to start all over again. That would not be an unreasonable thing to do for an RTM company in this position. I accept they didn't actually say that in the claim notice, but that doesn't matter for present purposes. Because if they had said it and one asks, what would Assethold have done? It is inconceivable in my submission that Assethold would have chosen just to stay away from the FTT proceedings. It would still have come along and said all the other things it said in its counter notice, the reasons why it said we should not get the right to manage. But if that's right, then the representation cannot have had any causal impact on anything that Assethold did, and that is fatal to the estoppel. Finally, on the appeal grounds, my learned friend said a number of times yesterday that we are not seeking to deny the jurisdiction of the FTT for any jurisdictional reason, as he put it, but simply to avoid a statutory costs liability. I'm not sure where that point actually goes, and there are 2 things I would say about it. First is that it reminds one of a submission one often hears in contractual disputes in commercial cases where somebody's terminated a contract. The other side almost invariably says they only terminated it because they wanted to escape a bad bargain or because the market had turned against them. But the courts have consistently said that what matters is whether they were entitled to terminate, not why they did it. People will only do anything because it's in their interest to do it. So it is in some respects, without intending any disrespect, a jury point. But there's also a substantive answer to it, which is it's actually not, as my learned friend sought to characterize, there's not a narrow dispute about costs. Because as the court will appreciate, if the RTM company wishes to seek to acquire the right to manage to this property in the future, and one can infer that it wants to do that from the fact that it tried to do it, it needs to know what Assethold status is and how the 2002 Act works. So this case is not a narrow dispute about costs, but a case that raises important points of principle that may affect what both this RTM company and other RTM companies may do in the future. Now, subject to the court, that is all I wanted to say by way of reply on my grounds of appeal, and I was proposing to turn next to the respondent's notice. I'm grateful, Madam. Now, in relation to the respondent's notice, the basic facts as we understand them are as follows. It is common ground that Assethold's purchase of the head lease from the other Millcastle entity, Millcastle POFW, has never been registered, whether at the time or subsequently, and more than 5 years have now passed. It is also common ground that the purchase of the freehold was registered only in 2023, pursuant to an application made on 29 April 2022, 2.5 years or so after the transaction.
Sorry, what was that date again?
29 April 2022, my lady.
Thank you.
So about 2.5 years after the transaction, after our claim notice is served, after we apply to the FTT.
Where do we get that date from?
It's tab 5 of the supplemental bundle.
That's the document which I don't recognise, which is a gov.uk printout.
That's right.
Yes. Can you
you
just talk me through
Of
what
course.
you say that
Yes,
says?
yes, of course, my lord.
Because it's not. I'm used to seeing official copies of the register rather than this thing which says it's not an official copy of the register. And if
Yes.
you need to prove things in a court case, you'll need an official copy.
No, I accept that.
So what is this? I can see it's come off the internet, but what does it actually tell you?
What we say tells us is, first of all, the title number NGL 925602. That's a reference to the freehold.
Freehold
That's
title.
the freehold title. If we then go, so it says last sold for £10,000 on 10 October 2019. That's the date of the transaction. But if we go over the page to the proprietorship register, and if we look at the entry numbers and the entry date is 29 April 2022. Now, under the land registration rules, I think it's rule 20, but I'll check the reference and come back to the court. Under the land registration rules, the entry date is always the date of the application, not the date on which the application is approved. It dates back to the date of the application. So we infer from these entry dates that the successful application to register the freehold was made on the 29th of April 2022.
Okay, so where do you get your 2023 date from? Because that's not obvious at all.
So that if we go to tab 4, sorry, not tab 4, tab 4 is the head lease, but tab 3 at page 7. As I understand this has been issued on the 22nd of February 2023.
Yes.
One can see that about the 4th bullet point on the top
Well,
of
that's
the
still got milk.
exactly. So it's after that the register.
Okay, but we haven't got the piece of information that shows us when it finally happened.
I don't believe we have.
What we do know is that going back to tab 5, accessed on the 12th of April 2023, and it shows the registered owner as Assethold.
Indeed, madam. I'm
Hang
sorry.
on, if you go back, I'm
By then.
I'm sorry.
So it's sometime between February and April 2023.
If you go back to page 7 and tab 3,
Yes.
what it appears to say is the official copy shows the entries on the register on 29th April 2022. So even though it's not issued until February 23, it seems to be showing the state of the register at an earlier date.
It does. And I was slightly puzzled by that, I confess. The only explanation I could come up with is that this is showing the state of the register immediately prior to the change.
But if that's so, then the change could have happened as early as April 2022.
Yes, it could have done. It could have done. I'm not sure that matters for the purposes of the point I'm seeking to make, which is it doesn't happen for some considerable time after the transaction. And I mean, no doubt my learned friend, when he replies, will correct me if I'm wrong, but we've made this point in our skeleton about the dates, and it's not our understanding that it's actually disputed. Now, I mean, this, I'm not going to pretend that the evidence is as clear as it could have been, but it actually ties in with the point I'm about to make, which is why is the evidence not there? And I'm going to submit this because this was never pleaded out before the FTT. So we have dug out what we can, but it's actually for Assethold to prove these things because they're the ones seeking to establish their standing. But I don't want to, I'll come on to that if I may. Now, so I made...
Just before we leave this, can I understand where these documents come from? Were they put in evidence below? Have they been put in evidence for this hearing?
May I just check that for a moment, my lord? I'm told they were put in evidence in the Upper Tribunal.
In the Upper Tribunal?
Yes.
By your side?
By our side. Yes. So I made the point about the dates. Now, no underlying contract for the sale of these interests, either the freehold or the head lease, has been disclosed. Indeed, no document has been disclosed other than file copies of the land registry TR1 forms, which are signed by the Mill-Castle entities but not by Assethold. And as the court will recall, when my learned friend helpfully took the court through the pleadings and the decisions of the courts below, the FTT actually found that the TR1 forms had not been executed validly.
Had not been, sorry, missed that.
Validly executed.
Okay.
So I make that point because it may just be worth emphasizing at this stage, this is not what one might describe as an ordinary registration gap case, where because of COVID backlogs or whatever else, it takes some time for the land registry to complete registration. Because the purchase of the head lease has never been registered, even though it's 5 years since the transaction. And there appears to have been, this is only an inference, but it seems to us a reasonable one, at least one unsuccessful application to the land registry to register the purchase of the freehold. I say that because if we are right that the successful application was only made on the 29th of April 2022, then it must have been a second application, because Assethold told the FTT in October 2021 in its pleadings that registration was pending then. So it seems that there was already one application, which for whatever reason was rejected by the land registry, and then another application, potentially with a different TR1 form, which is then registered. And what supports that inference is that Millcastle POFW, the transferor of the head lease, was dissolved, I believe in September 2021, in which case it wouldn't have been able to execute a new TR1 form, which may explain why that's never been registered. I mean,
What's happened to the title?
I believe it still shows Millcastle POFW.
It can't be vested in PFW if it's been dissolved.
No.
It's vested in the Crown as beneficentia.
Yes, my lord. I don't know what, but I mean, I don't disagree with that. But the point is, the transfer has not been registered. So it's all slightly murky. And one point I want to make before I turn to the substance of the respondent's notice is, it was suggested at various stages in the course of submissions yesterday that my client has always known that Assethold has been doing the cleaning and the maintenance, and that there's never been any doubt about Assethold's status as a landlord. This point has been taken at the last minute to avoid a cost liability. Now, I want to be very careful not to refer to any documents that are not in evidence before this court. But what I can say is if those points, those assertions had been made below, they would have been disputed. Had these points been pleaded out, they would have been disclosure and evidence. And there was actually a disclosure application, which I'll go to. But my client does not accept that it always knew Assethold's status as a landlord. Now, as my Lord Justice Nugee pointed out yesterday, and I obviously accept this, my client chose to serve the claim notice on Assethold. It did. But one can't infer from that my client believed or knew that Assethold is a landlord. It was an equally consistent alternative inference is that it wanted to reduce the scope for things going wrong by somebody taking the point that you haven't served everyone who should have been served. It's the sort of point landlords often take under the 2000 law. And I mean, which is right is a matter that would need to have been the subject of factual findings below. So against that background...
Sorry, and just a very small point on the cleaning, etc. One assumes, and we've talked very little about this head lease, but the relationship, assuming there aren't other intermediate landlords for the moment, the relationship the tenants technically have is with the landlord under that head lease, rather than with the freeholder. In other words,
yes.
The service charge, etc. provisions,
yes,
you would expect to be in between the head lease.
Yes.
Millcastle POF, the entity that was Millcastle
Yes.
POFW as head lessee,
yes,
and these
individual.
tenants. So when they're paying service charges and so on, wouldn't it be under the terms of those leases,
Yes, I imagine.
not their relationship with the freeholder?
Yes, I imagine so, my lady. There's no evidence of that, but it stands to reason that you would pay service charge under the lease to which you're a party.
Provided that lease still
Yes,
exists,
quite,
and we don't know,
quite. We don't know.
as has been pointed out, we don't know whether it does.
No. And I'm actually going to make a point about that. That hasn't been disclosed either, the head lease, but I respectfully agree with that. Now, against that background, our first answer to the respondent's notice points is that it is not open to the respondent to take them in this court. And we say that for essentially three reasons, which I can take pretty quickly because I've covered the ground. First, the premise for the respondent's notice is that they have acquired an equitable interest. It's not entirely clear to us if they say they acquired or needed to acquire an equitable interest in the freehold or the head lease, but on either basis, that's the premise. But Assethold could not have acquired an equitable interest in the property unless the TR1 form saw some antecedent contract between it and Millcastle complied with the requirements of Section 2 of the Law of Property Miscellaneous Provisions Act 1989. We know the TR1 forms, at least those disclosed, did not comply with Section 2 because they're not signed by Assethold, which is required by Section 2, subsection 3. And there is no evidence of any antecedent contract. I mean, we don't even know if there was one. Now, if Section 2, even assuming Section 2 was complied with, whether Assethold actually had an equitable interest in either the freehold or the head lease would raise further factual issues, because there are other reasons why it might not have had an equitable interest on the date of the claim notice, some of which were put to my learned friend yesterday by my Lady Justice Falk. For instance, if the purchaser holds on a bare trust, or if the purchaser has disposed of any equitable interest after the date of the purchase, but before the date of the claim notice. I am not advancing a positive case that that actually happened. I don't know what happened. But the burden of proof, and this is my second point, the burden of proving these matters is on Assethold because it is not axiomatic that it acquired an equitable interest. It's a question of fact, not logic. Now, if we are right that it's A, not axiomatic, and B, that the burden is on Assethold, then the problem for Assethold is that it did not plead or prove before the FTT that it had acquired an equitable interest. Nor did it disclose any document which would satisfy the requirements of Section 2 of the 1989. And there was no evidence before the courts below upon which they could have made a finding that it had acquired an equitable interest. Now, just to make that point good about the pleadings, my learned friend took the court through them yesterday, so I don't need to do it in detail. But the court may recall that in my client's statement of case dated 23 November 2022, before the FTT, in the cost litigation, we expressly put in issue Assethold's status as a landlord. So that is, just to give the court a reference, supplementary bundle, tab 24, page 203, para 13. So that's 23 November 2022. In response, Assethold served a statement of case on the 7th of December. So after they know that we have put their status as landlord in issue, that, it may be worth turning it up, is tab 25, the supplemental bundle. And if we go to, so since this statement of case in response, it's tab 25, page 214. Since this is served in response to our statement of case, putting in issue their status, one might expect it to plead that we have acquired an equitable interest and we are therefore a landlord. I mean, that's what one would expect the responsive statement of case to say, but it didn't say it. At page 218, at the bottom of page 218, paragraph 13, which is where this point is dealt with. It says, as noted by the respondent, the applicant purchased the freehold, etc. on 10 October 2019. A copy TR1 has been provided as evidence of the transfer and was a final copy, file copy of the final document, which is why the signature is absent. The applicant confirms that the application is still pending at the land registry. And then it says over the page that we were aware of the capacity of the applicant in this matter, having given the copy claim notice. And then paragraph C takes the estoppel point. But what none of this says is that they'd acquired an equitable interest, still less particularized the grounds on which they had acquired it. So the way the point actually emerged was after they lost before the FTT, which held that they are not a landlord because they don't have a legal interest. The point was then taken for the first time in their application to the FTT for permission to appeal, grounds 2 and 3. And that is, again, to give the court a reference, tab 26, page 231.
Sorry, tab.
Tab 26, page 231. So while one doesn't take procedural points lightly in this court, the fact that this is how the point emerged does give rise to a question whether the respondent is entitled to take the point, and we submit not in the light of the guidance given most recently by Lord Justice Popplewell in the Rhine shipping case. And perhaps I can quickly go to that. It's the most recent authority on the point. Supplemental bundle, tab 4. Supplemental authorities bundle, I should have said, tab 4. I'm so sorry, it's tab 5, I apologize. Tab 5, page 147. And the relevant passage is at paragraph 24 at page 161.
Paragraph
24 at the bottom of 161.
Thank you.
Lord Justice Popplewell said there are aspects of such guidance which I would emphasize as of importance to the present case. First, the caution about allowing a point to be raised for the first time on appeal, irrespective of whether it affects the evidence or argument which would have been advanced at trial, reflects a policy both of fairness and of the efficient use of court resources, which was encapsulated by Lord Justice May. And then in the quotation, I wanted to draw attention, if I may, to the penultimate sentence in Lord Justice May's judgment, beginning with the words, litigation should be resolved once and for all, and it is not, generally speaking, just if a party who successfully contested a case advanced on one basis should be expected to face on appeal not a challenge to the original decision, but a new case advanced on a different basis. And pausing there, we respectfully submit that is exactly our case. We successfully contested before the FTT the costs application as it was then put, which was founded on and only upon estoppel. In the application for permission to appeal, a new point emerged, which is, even if there's no estoppel, we are in fact a landlord by virtue of the alleged equitable interest. And that is the vice to which that principle is directed, quite irrespective of questions of prejudice. But the second point I wanted to make is about prejudice, which is at para 26 at the bottom of page 162. Secondly, it will usually be fatal to the new point being permitted to be raised for the first time on an appeal if there is a real possibility that had the point been taken at trial, evidence could have been adduced which might have affected the outcome. As Lord Justice Norse put it in a well-known case on this point, Petalis and Grant, the stance which an appellate court should take towards a point not raised at the trial is in general well settled. It is perhaps best stated in Firth, per Sir George Jessel. The rule is that if a point was not taken before the tribunal which hears the evidence, and evidence could have been adduced which by any possibility would prevent the point from succeeding, it cannot be taken afterwards. You are bound to take the point in the first instance so as to enable the other party to give evidence. So it's quite a low bar. Is there some possibility that relevant evidence could have been adduced which might have affected the outcome? I don't have to show that I would have won on the facts had the point been pleaded out. And there is, we would submit, in the light of the lack of clarity about what actually happened with the land registry, at a minimum, a real possibility that new material evidence could and would have been adduced.
Are you going to address what the FTT actually said?
Yes, my lady. That's. I was going to do that next, if I may. Core bundle. Tab 13, page 135. Para 16 at page 135 makes factual findings about the date of the transaction, the fact that only 5 copies were disclosed, and so on.
Well, I mean, 14 says the purchase of the freehold and leasehold is completed. but
Yes.
yet to be registered.
Yes. So, but that only helps the respondent if the mere fact of completion is sufficient to give rise to an equitable interest, absent any further facts.
Well, you've talked about section 2.
Yes.
But that isn't the only way of conferring an equitable interest. If there was a completed purchase with payment, might that be another way?
Well, my lady, section 2 is in a special category of the 1989 Act, because if your contract doesn't comply with section 2, sorry, let me just take this in stages. I accept that section 2 does not apply, and the number of authorities make this point, to a document that actually conveys property. So for instance, if the TR1 forms in this case had been validly executed and registered, nobody could take any point about section 2. But if what you have is not that, a document which conveys an interest, if what you have is a contract for the sale of an interest in land, and it doesn't comply with section 2 because it's not in writing or it's not signed, then it's void. It can't give rise even to an equitable interest, let alone a legal interest. So if you complete, but you haven't signed the relevant document, there's no equitable interest. Now, we don't know what happened, what the
Is
document...
that right, if payments actually made?
Yes, in my respectful submission, it is. I mean, there's some authority on that. I can give the court 2 references. One is Darian and Hurley, which is concerned with a defective lease. That's at volume 2, tab 37. Now, this is a case, very quickly to summarize the facts, conscious of time, it concerned a challenge to a bankruptcy petition, which was founded on debts allegedly due under a lease. And Mrs. Hurley took the point that the lease was defective because her signature hadn't been witnessed. And at paragraph 12, if we just go over the page. Now, I accept, my lady, there's no positive finding here that everything had been performed, whereas your ladyship's question to me was, what if the money has been paid? But because many years had passed after the execution of the lease, I infer that substantial performance had taken place by the time this dispute arises. And despite that, what the learned deputy judge says at paragraph 12 of page 537 is that the deficiency in the execution of the lease as a deed is manifest and it does not comply with the requisite statutory requirements. It therefore takes effect only as an agreement to do the lease, which is susceptible of being perfected by an order for specific performance. Under the well-known doctrine Walsh and Lonsdale, equity treats the parties as if the lease has already been granted, so long as specific performance would be granted. So the critical thing for an equitable interest to arise, I mean, this anticipates a point I was going to come on to, but I can cover it now. One has to ask, what is the equity? What is the source of the equitable interest? And it is the fact that if a contract is capable of specific performance, then you have a duty, an enforceable duty, to do that which you promised to do. And equity treats as done that which ought to be done. That's what gives rise to the equitable interest. But if you don't comply with section 2 of the 1989 Act, you won't get specific performance. So there's no equity. I mean, this ties in with the point my learned friend Ms. Gibson made yesterday, which is, if you're in the registration gap, you have an equitable interest. And I accept, of course, that most purchasers in the registration gap will have an equitable interest. But one's got to ask, why is that? It's not because there's some magic in the phrase registration gap or because it's any particular term of art. It is because almost all the time, or often, during the registration gap, there will be a contract which complies with section 2 of the 1989 Act, which is pending registration. And that contract, because we're talking about land, will almost always be capable of specific performance. That's what gives rise to the equity. Now, overnight, we have identified 2 passages, and I've given this to my learned friends in Chitty and Snell, which reinforces this. May I, with your ladyship's permission, hand those up? And
You've got copies, Mr. Bates and Miss Gibson, have you? Good.
don't know if what the court has before it is Snell or Chitty. We should have printed the title page, and I apologize for not doing that. But in Snell, it's paragraph 5014.
I've got two copies of the same thing.
Yeah. Yes. She's got. Thank you.
Paragraph 5014 is Snell,
Thank you.
and about halfway down, yes, and halfway down it says, if, for example, the grant of a particular lease requires a deed or registration, if the court has that, no legal lease can arise in the absence of those requirements. An equitable lease, by contrast, depends not on a grant, but on A's coming under a duty to grant B a lease in the absence of a deed or registration, does not prevent there being a contract between A and B that can impose such a duty. So it's that fact, the duty, the ability to get specific performance, that gives rise to the equitable interest in cases concerning the registration gap. And the same point is made in Chitty, just to give the court a reference. Paragraph 8026 at internal page 714. And just taking a step back, my ladies, my lord, that we would submit must be the right analysis, because equity would not contradict the statute. The reason why in this, as in many other areas of equitable principles, what equity is enforcing in these cases is not the defective instrument, but the duty of which that instrument is evidence. Namely, you have promised to convey. Because it's not yet been registered, I haven't got legal estate. But what equity enforces is not the instrument. If it did that, it would be contradicting the statute. It's enforcing the duty. I mean, it's a bit like in the conflict of laws. There's a long line of authority about whether you can get relief in the English court in cases concerning foreign land. I think the case is called Mozambique many years ago. And what the courts have consistently said is, we are not enforcing, or we are not making any declaration about who owns foreign land. We act upon the conscience of the defendant because they have made some promise or they've acted in a way which is unconscionable for them to go back on. So one's always got to identify the equity in order to say that there's an equitable interest. It's not the bare fact of a registration gap, it's the ability to obtain specific performance.
I think the authority for that proposition is Landlord Baltimore,
Yes.
in which the Court of Chancery decided where the dividing line between the states of Pennsylvania and Maryland.
Yes, indeed, my lord. I'd forgotten that. That's it. And I think that was been cited with approval many, many times since then. But so that's my first answer to the question my Lady Justice Falk put to me. It's not axiomatic, but there's another more specific answer. We don't actually know when the purchase price was paid. Even assuming that's enough to give rise to an equitable interest, we asked for evidence of that. It's page 158 of the disclosure application that my client made in the Upper Tribunal, and this may be a convenient moment to go to that. It's tab 13 of the supplementary bundle. This was an application made to the Upper Tribunal because, as I explained earlier, the point had only emerged there, not in the FTP. And if we go to page 128, it identifies the documents of which we were seeking disclosure. Copies of sale and purchase agreements, copies of all agreements, etc. Now, one slight oddity in all this is these are all documents which must, if they exist, be in Assethold's possession. If a litigant in Assethold's possession has an equitable interest, the obvious thing to do, we would submit, would be to disclose the documents, because that would kill off this point. It would show, if it were the case, that Section 2 has been complied with, if relevant, purchase price has been paid. But for whatever reason, which has never been explained, none of these documents was disclosed. And the application we made to the Upper Tribunal wasn't determined because it became academic once we lost on the estoppel point. But if we go to page 158.
So the Upper Tribunal just left this application.
Yes.
We didn't need to determine.
Yes. And that direction is actually at page 159. It's the next tab, where the tribunal said we will determine the application if you win on ground one, but then we lost on ground one, so it all fell away. But I should just point out, that I'm grateful to my learned junior, at tab 32, Assethold positively refused to disclose these documents. Tab 32, page 249. That's what prompted our application. I mean, in the usual way, we asked them in correspondence first. They refused, then we applied, but the application was parked and then became academic. But just to finish off on the point my lady was putting to me, if we go back, please, to page 158. We actually asked for evidence that the purchase price has been paid. And one can see that at the top of the page. Evidence that any amounts due to Millcastle Properties or Millcastle POFW were in fact paid. And we explained why we needed that. Because we didn't know and we still don't know. So even taking the respondent's case at its highest and para 14 of the FTT at its highest, it's not sufficient to establish that there was an equitable interest on the facts. And if I'm right about that, then the point can't be run in the light of Rhine shipping because it requires further evidence. I should also deal with one further passage in the FTT judgment on which my friends.
Sorry, yes, I took you 14, you were talking about 16.
Yeah, 16 is just background, it introduces the
Yes.
facts. And then 17 points out that Assethold has not given any explanation for the delay, not disclosed the document. Then 18 says that the transfer, 18 is a key passage because my learned friends rely on it. 18 begins by saying there's no interest in law because of section 27. Then it says Assethold only has equitable rights as against Millcastle. Now, it's trite that any judgment must be read in context. We say that's not a factual finding that Assethold has equitable rights. The key word in that sentence is the word only. What the FTT is saying is that Assethold could only have had equitable rights. I accept it doesn't actually say that, but that must be what it means in context. Because the FTT has made a finding they don't have a legal interest. There's no evidence before it, and the point has not even been pleaded that there's an equitable interest, so it couldn't have made any factual findings about it. The use of the word only tells us that what the learned judge is seeking to explain is that the only thing you could have had is something that's not good enough, namely equitable rights.
If we were to take the view that there was a finding there, would you say there was no evidence on which it could be based?
I would respectfully say that, my lady. No plead, not only no evidence, no pleaded case. Because this all comes in, as I pointed out earlier, after they lose and at the permission stage. I mean, we're all very familiar with the famous passage in Lord Justice Lewison's judgment that the trial is not a dress rehearsal. But if one were just to think about this in courts, I more regularly appear in Commercial Court or Chancery Division, it's the equivalent of losing at trial, let's say a 4 or 6 week trial, and then at the consequentials hearing saying, I want to take a new point, which would require further evidence. It would be given short shrift. And if you then try to revive it in this court, you would have an even more difficult task. But it's not analytically different because the FTT is the equivalent of court of first instance. So we do say, for those reasons, the point is not available. Now, if I'm wrong about that, such that the substance of the point arises for determination, that raises interesting and difficult points of law. I would accept they are difficult. Can I just say, our case is, there are 2 reasons why the respondent is wrong, even if it had established on the facts that it has an equitable interest. It would still not be a party to any of the leases. And that's what's required under Section 88 of the 2002 Act. And I'll develop that in a moment. Secondly, save perhaps in one situation, which is not relevant to this appeal, the word landlord in Section 88 does not include the holders of equitable interests. And indeed, if it did, the 2002 Act would become unworkable. Now, I'll take those 2 points very quickly and then deal briefly with my learned friend's answers to them. My first point, which is the party point, is this, and I briefly foreshadowed it in my opening submissions yesterday. If we go back for a moment to section 79, please, of the 2002 Act, volume 1, page 13, tab 1, page 13. (79.6) says this. I mean, you obviously looked at it many times. The claim notice must be given to each person who on the relevant date is A, landlord under a lease of the whole or any part of the premises, B, party to such a lease otherwise than as a landlord or tenant. We say the words otherwise than are significant because it is implicit in those words that somebody within 79.6a must also be a party to a lease. So A is saying you're a party as a landlord, B is saying you're a party otherwise than as a landlord, but what's common to both is that you must actually be a party. So at the risk of using terminology that can be slightly imprecise, what 79.6 requires is not merely privity of estate, but privity of contract. You must be a landlord under a lease by being a party to it. And if one thinks of, because I'm going to deal with the 1995 Act, which my Lord Justice Nugee referred to yesterday, it does provide, I accept, that upon an assignment, covenants become enforceable. I accept that. But if we just take this in stages, on day 0, as it were, so before there's any kind of transfer, you would have the freeholder who, let's say, grants a head lease. At that point, there is privity of contract because they are the two people involved and they are parties to the lease. At that point, the 1995 Act could not even kick in because there's not been any transfer. So if one applies 79 at that stage, what it's saying is you are either a party as a landlord or otherwise than as a landlord, but in both cases, there's privity of contract. Now, if that's right, the same words in section 88 must mean the same thing. Landlord under a lease, a party otherwise than as a landlord. You must actually be a party. And if I can just make this point very quickly, my learned friend went yesterday to section 96, which is at page 36. It reinforces the submission I've just made, which is that you need privity of contract. Because subsections 2 and 3 define the management functions which go across to the RTM company once its claim succeeds. But then subsection 4 refers to any provisions of the lease. So it's talking about individual provisions of the relevant leases of certain types which constitute management functions. So some won't. So not every provision in every lease will relate to a management function. But what this is talking about is powers the landlord has before the RTM company acquires the right to manage under the lease by virtue of being a party to it. And there are other provisions which in the interest of time I won't go to, but which also demonstrate that the phrase landlord under a lease is a reference to someone who's actually a party. But just to give the references, they are section 97, section 98, subsection 2, and section 100, subsection 5. Now, in this case, even assuming, contrary to all the submissions I've made so far, that Assethold has established on the facts that it acquired an equitable interest on the 10th of October 2019, that would not make it a party. That would not of itself make it a party to the head lease or any other lease. Now, the head lease has not been disclosed, but the reason why I submit that it's unlikely to have become a party just by virtue of the equitable interest is general principles of equity referred to by Mr. Justice Fancourt in the Sackville case. If I can just go to that, it's volume 2, tab 32, page 462. Now, if I may very quickly summarize the facts, this case concerns an office block in the city called America House. Part of America House was leased to a company called Robertson for a term of 10 years, and that lease was registered at the land registry in Robertson's name. Clause 6.10 of the lease contained a break option for the tenant, exercisable by notice of not less than 9 months, expiring on 14 March 2018. So far, it's a standard case which doesn't raise any difficulties. But what happened is that Robertson's business was acquired by a third party called the Integro Group, just a normal corporate acquisition. With the landlord's consent, Robertson assigned the lease it held to Integro because it needed to do that. But before the transfer of the lease was registered, so before Integro acquires a legal interest in the lease, it purported to exercise the break option on the basis that it was now the tenant. And the issue in the case was whether it was entitled to do so. Because the reason it arose, one might think, why can't you just do it again? It's because most break clauses are temporal. If you don't get it right, that's it. You can't do it again. So everything turned on whether they could do it. Mr. Justice Pancourt held they were not entitled to exercise the break option despite the 1995 Act, despite Section 24 of the Land Registration Act. And that was because, he said, Integro had not become a party to the lease despite having an equitable interest in it, and was not a tenant with a capital T as a matter of construction. His reasoning begins, well, actually we should start with paragraph 5 at page 465. So we get there the definition of landlord and tenant in the lease. So far as I'm aware, fairly standard definition. It says, shall include their respective successors and title, personal representatives, and any person in whom the lease may from time to time be vested by whatever means. So under that definition, landlord and tenant aren't necessarily confined to the parties who originally entered into the lease. It would include all these other people, successors, people in whom it's vested, and so on. And at para 8, the learned judge quotes the break option, clause 6.10, which says the tenant with a capital T may exercise it, and the dispute in the case is about its construction. The relevant passages are paras 28 and 34. At para 28, having referred to an earlier case, the learned judge says, in that case, the notice was a case B notice under the Agricultural Holdings Act 1986. Such a notice must also satisfy the requirements for a common law notice to quit. Here, the break notice is a contractual notice required by the terms of the break option, clause 6.10 of the lease. This requires not less than 9 months prior written notice to be given to the landlord by the tenant. As defined in clause 1.2.1, tenant includes the successors and title of Robertson and any person in whom the lease may from time to time be vested by whatever means. Until Integro was registered, the lease, which is a legal term of years, remained vested in Robertson, and Integro did not yet have title to the lease. The lease was held by Robertson on trust for Integro. As a matter of interpretation of the break option, therefore, Integro does not appear to be the tenant at the date of service of the break notice, and so the notice must be served by Robertson. Now, that paragraph uses the words does not appear, which may seem equivocal, but there's another passage where the learned judge says the same thing. But before I go to that, just picking up on the question my Lord Justice Nugee asked yesterday, if we look at paras 29 and 30, the learned judge refers to the 1995 Act, the Landlord and Tenants Act, and indeed he says that he thought that to be the most promising argument in favor of the tenant. That's at para 29, 4 lines from the bottom. Now, in response to that, counsel took the point which was briefly discussed yesterday, which is, does the word assignment in the 1995 Act itself require registration? The learned judge said it doesn't. That's at paragraph 32. But he then said, despite that, despite the 1995 Act saying you can enforce covenants in the lease, it doesn't enable you to serve the break notice because, and that's at paragraph 33, the obligation of a landlord, etc., is the obligation to treat the lease as terminated with effect from a specified date if a valid break notice is served, but the obligation is triggered only if the condition is satisfied, etc. And then the critical passage is 34. In my judgment, although the lease created a new tenancy to which the provisions of the Act of 1995 apply, the Act does not vary the meaning of the condition in the break option. Integra was not on 2 May 2017 the successor in title of Robertson, within the meaning of clause 1.2.1 of the lease. Title to the legal term of years remained with Robertson, nor was the lease vested in Integro, even though Integro by statute had the benefit of the landlord covenants of the lease. On the contrary, the lease remained vested in Robertson, but Robertson held it on trust for Integro. And then at 37 and 38, which I won't read, the learned judge rejected a similar argument based on another provision on which my learned friends rely, Section 24 of the Land Registration Act 2002.
Right, just on the 1995 Act, as I think as Justice Fancourt picks up, the relevant provision, Section 3, only applies to leases granted after the Act was brought into force. We don't know that, I don't think we know the facts of this case, but it's important, it may be relevant to recognise that there are different categories of lease. There are some to which the 1995 Act applies, and there are all the leases to which it does not.
Yes, I mean, that hadn't occurred to me, but I respectfully adopt that, my lady. That would be a further problem. I mean, it would be a further factual issue on which Assethold should have led evidence. But
Well, I mean, I was thinking more that to the extent it might be said that the statutory background of the 1995 Act should inform the construction of the 2002 Act as to whether landlords should include equitable
yes,
landlords. That was my point. You've got
yes,
the 2002 legislation covering all sorts of leases,
yes.
many of which, because they're long leases, would have been granted before that Act was brought into force.
Yes, I see what your ladyship means now. But the point I was making earlier, before I went to Sackville, was that as a matter of construction, the word landlord, it's not actually just the word landlord, it's the words landlord under a lease, etc. We say that means you have to be a party, for the reasons I gave earlier. The use of the word otherwise in 79.6b, 88.1b, 96 and so on. Now, if I'm right about that as a matter of construction, then whether you in fact are a party to a lease doesn't turn on the construction of the 2002 Act, but just on the application of general equitable principles, including the 1995 Act if it applies. So in a sense, the argument comes in at two stages. The first is, what do the words landlord under a lease mean? We say, for the purposes of this argument, it means somebody who's actually a party to the lease and has privity of contract. We're either right about that or wrong about that. If we're wrong about that, Sackville won't help me. But if we are right about that, then Sackville helps me because it shows that even with the benefit of provisions like the 1995 Act or Section 24 of the 2002 Act, you don't actually become a party to the lease and you can't serve notices. That would then be sufficient for me to defeat the respondent's notice points, even if I've lost on all my prior points. But I accept that if I'm wrong about what the words landlord under a lease mean, if the court were to hold you don't have to be a party, it is sufficient that you can enforce some of the covenants in it even without being a party, then Sackville won't help me. But in my submission, that's not the right construction of the 2002 Act, partly because it would mean one's got to define which covenants you need to be able to enforce by virtue of the 1995 Act in order to become a landlord. There's no statutory definition of that. It would cause very considerable uncertainty. Indeed, one would have to look at each individual lease, individual provisions of it, and work out whether, in the traditional language of equity, they touch and concern the land, because then they'd be caught by the 1995 Act. But that would make, and this anticipates the point I'm going to come on to, the 2002 Act even more difficult to apply. I mean, there's no way an RTM company could work out all of this. They wouldn't even have a copy of the lease. Whereas on my submission, where you've got to be a party, that's much more straightforward and clearer to apply and consistent with the language, especially the word otherwise. So that's how I put the Sackville point. In answer to this, and I'll deal with this relatively briefly, my learned friends relied on the RM residential case, which is an Upper Tribunal decision. 2 points on that. 2 reasons why it doesn't assist my learned friends. First, it's not actually a case about whether the applicant had become a party to the lease. That's not what the issue was in that case. The issue was whether the applicant was a landlord for the purposes of Section 20 capital ZA of the Landlord and Tenants Act 1985 for dispensation. But so it's irrelevant, because if I'm right that you need to be a party, then it's not enough to be a landlord. You have to be a landlord by virtue of being a party to a lease. And there's nothing in RM residential that assists on that latter question. So that's the first reason why RM residential with respect doesn't assist my learned friends. The second is Judge Cooke in that case took a relatively expansive approach to the effect of Section 24, the Land Registration Act. But neither Sackville, the case we've just looked at, nor Skelwith, a case I'll go to if I don't run out of time, which I probably will, appears to have been cited to Judge Cooke. And both of those cases explain that Section 24 of the Land Registration Act does not mean that an equitable owner can do everything that a legal owner can do, or even most things. For instance, you can't serve a notice to quit. You can't serve, as we've just seen, a notice exercising a break clause. The meaning of the words of the lease don't change. So RM residential doesn't assist. That's my first point, my party point. But even if I'm wrong about the party point, if I'm wrong about the party point, then we get into what is probably the most difficult question that arises on the respondent's notice, which is looking at the word landlord in isolation. Is that a reference to people who have a legal interest, or also to people who have equitable interests? And just to be clear, this only arises if I'm wrong about the party point, because for the party point, I'm prepared to assume that they're a landlord, but it's not enough. You've still got to be a party. But on the landlord point, there's some authority, albeit not on all fours with this case, that suggests that the 2002 Act is not concerned with beneficial interests. One of those is the Sunny Gardens case, which I don't think we've looked at. That's Volume 1, Tab 12, page 162. And the relevant passage is paragraph 29 at page 170.
Paragraph?
29 at the top of 170. This is about qualifying tenants, which is why I accept it's not on all fours with our case. But what the Upper Tribunal says is, to be the qualifying tenant of a flat, a person must be a tenant. The tenant referred to in section 75(1) is the person in whom, for the time being, the legal estate created by the lease is vested. As the LBT correctly observed, the 2002 Act is not concerned with beneficial interests. Now, I adopt that observation that the 2002 Act is not concerned with beneficial interests. It was actually endorsed, that observation, by the Law Commission in its consultation paper in 2019. Just to give the court a reference to that, that's Volume 2, Tab 47, page 608, 608. So that's Sunny Gardens. The second authority, which perhaps came to be the bedrock of my learned friend submissions, is Cresta Court, the more recent decision of Judge Cooke. Now, we say that that's actually an authority in our favor because of a point that was put to my learned friend yesterday by my late Justice Falk. Now, very quickly, you probably recall the facts. It's a supplemental bundle, tab 1, page 1. It's a property in which there was one flat, flat 17, which was occupied by Miss Beverly O'Connor, who had been granted a lease of 150 years, but that lease had not been registered. But the important thing to remember about Cresta Court is that there was an equitable lease in existence, but no legal lease at all. And that there's a finding to that effect in paragraph 21 of Cresta Court at page 8. Where Judge Cooke says, at the date of the claim notice, and crucially 14 days beforehand, Miss O'Connor held an equitable lease of flat 17, and there was no legal lease in existence. That's important because this case is concerned with who the qualifying tenant is if X has an equitable lease and nobody has the legal lease, because there just isn't one. And then if we go to para 59 at page 15, Judge Cooke says, so where there is both a legal lease and an equitable lease, whether in the sense of an agreement for a lease or of a granted lease that is registrable and has not yet been registered, the context does not permit that the equitable lessee is the qualifying tenant. In those circumstances, the qualifying tenant is the legal lessee. That's consistent with the analysis in 7 Sunny Gardens, which we just looked at. And then in para 63, the learned judge held that if you've got no legal lease at all, but only an equitable lease, then the equitable lessee may be a qualifying tenant. So that's the distinction she draws. But in our case, it's common ground that there was at all material times someone who had the legal interest in both the freehold and the head lease, namely the 2 Mill Castle entities. So adopting by analogy the reasoning in Cresta Court, Assethold's alleged equitable interests are irrelevant, because this is not a case where those are the only interests. My next and probably final point is a more general one about the purpose of the 2002 Act. If the court were to hold that the word landlord includes people who have equitable interests, even in cases where you've also got a legal interest, we say that that would be contrary to the purpose of the legislation as recently explained by the Supreme Court, and indeed potentially make the Act unworkable. Again, 2 points in support of that. First, although this is ultimately a question of construction of each individual statute, the starting point in property legislation is that the words landlord and tenant are usually a reference to legal owners, not equitable owners, because the legislation would usually be unworkable if it were otherwise. And I use the word usually because I accept this is ultimately a question of construction. But that's normally the likely outcome of the exercise of construction. Now, this point is actually made in one of the textbooks cited by the respondent. It's Haig on leasehold enfranchisement. I won't go to it, but the reference is volume 2, tab 43, page 583. Now, they cite in footnote 2 a Court of Appeal authority in support of that proposition that normally in property legislation, the word landlord is a reference to legal rather than equitable owners. And the case they cite is Pearson, which we have in the bundle. That's volume 2, tab 25. Volume 2, tab 25, page 380, Pearson. Now, this is it's an interesting case in which Dr. Allio and his wife were registered as joint proprietors of a hotel called the Brindle House Hotel. But Dr. Allio had paid for the whole thing with his own money. And so it was assumed that his wife held her interest on trust for him. What then happened is that Dr. Allio served a notice on the tenant of the hotel under Section 25 of the Landlord and Tenant Act, 1954. But what he did was he named only himself as a landlord, not his wife. And the tenant contended subsequently that the notice was invalid because his wife should also have been named as a landlord. The judge at first instance rejected that argument. But if we could go to page 381, towards the bottom of the page at letter M, Lord Justice Knowles said, there can be no doubt that the landlord thus defined are the respondent and his wife. They are the joint owners of the legal estate in the property, being the interest in reversion immediately expectant on the termination of the appellant's tenancy. Counsel advanced an elaborate argument to the effect that it's the respondent alone, as the person solely and absolutely entitled to the property in equity, who is the landlord for the purpose of section 44(1). That argument was misconceived. The section is concerned only with legal owners. The act would be unworkable if it were otherwise. Now, I accept that's about a different legislation. I don't say that's binding, but it is useful guidance as to what the answer is likely to be if somebody runs the point my learned friend is running about a property legislation. So that's my first point, the Alio case of the Pearson case. My second point concerns the 2002 Act itself. What is its purpose? I'll go to A1 properties in a moment, but its purpose is quite clear. It was to provide tenants with a simple and inexpensive method of acquiring the right to manage. The procedure was intended to be straightforward to operate, and it was probably envisaged that it would not be the subject of much litigation. If we can go to A1 Properties, Volume 1, Tab 10. At page 1, sorry, tab 10, page 122. So the Supreme Court referred in paragraph 22 to the background, to the enactment of the 2002 Act. Then at 23, they refer to a consultation paper issued by the government. And then if we go over the page to 25, please, page 123, paragraph 25. The consultation paper described the overall objective of the proposals in this way at paragraph 10 of section 3. The main objective is to grant residential long leaseholders of flats the right to take over the management of their building collectively without having either to prove fault on the part of the landlord or to pay any compensation. The procedure should be as simple as possible to reduce the potential for challenge by an obstructive landlord. The allocation of responsibility should be clear-cut, etc. Now, I mean, the courts have often pointed out that that hasn't actually come to pass. And I don't think that's actually...
Underestimated the ingenuity of the landlords.
Well, indeed. And my learned friend very fairly accepted yesterday. And I don't criticize somebody for taking technical points. People take the points they take. But the point is, this is the objective of the Act. But if we then go to para 47 at page 129, at the bottom of the page, there's a quotation from a judgment of Mr. Roger QC in the Triple Rose case, where he says, it's an example of something courts have frequently said. Small and apparently insignificant defects and notices or failures of strict compliance are relied on again and again by landlords seeking to stave off claims to acquire the right to manage and to avoid the resulting losses of control. And then, more significantly for present purposes, at paras 97 to 98, at page 142, at the bottom of page 142, para 97, my learned friend was the Supreme Court was dealing with my learned friend's contention in that case that it's easy for an RTM company to start afresh by serving a new claim form. And I think my learned friend was submitting, because it's easy to start again, you should construe the requirements of the Act strictly, because the right isn't lost forever, you can just do it again. Now the court's answer to that is at para 98. First, the purpose of the legislative scheme as explained in the consultation paper includes the objective that opportunities for obstructive landlords to thwart the transfer of the right to manage should be kept to a minimum. The procedural requirements have not been included to create traps for the unwary, nor to afford unwarranted opportunities for obstruction on the part of objecting landlords, who have not themselves been significantly affected by any particular omission to comply with them. So I don't think it will be disputed that that is the purpose of the 2002 Act. So that's the purpose against which the construction for which my learned friend contends in this case falls to be tested. Would it be consistent with that purpose if the word landlord were to include equitable owners even in cases where there is a legal owner. We say it would not, because, ladies, my lord, it's already the case that there is no simple and conclusive way for an RTM company to check who the landlords are. Because even the holders of legal interests are not always discoverable, say because there's a short-term lease which doesn't have to be registered. And as the Supreme Court noted in para 98, the tenants lack the means to determine with confidence whether there are intermediate landlords. So there are already problems. But if the word landlord includes the holders of equitable interests, the difficulties would only multiply, indeed to the point that it would become, we would suggest, virtually impossible, or at least very difficult, for an RTM company to serve a claim notice confidently, because it could not do so without undertaking inquiries as to the possible existence of equitable interests and the identity of those holding them. If such an inquiry were required in every case before you serve a claim notice, which would be the consequence of what my learned friend is stating, then the procedure would be the opposite of the simple and inexpensive procedure envisaged by Parliament, and the obstructive landlord to which the Supreme Court referred in A1 Properties would have still further grounds for objecting. Because they would say, this other person you served, but actually he held his interest on a trust for someone else and you didn't serve them. So go and start all over again.
Just on that, the Supreme Court solution in A1 for treating claim notices as voidable rather than automatically void if they weren't served on, say, intermediate landlord, as in that case. Does that affect the strength of your argument?
Yes, that is, if I may say so, my lady, a very fair question. I accept it affects the strength of my argument. My argument would be stronger if the failure to serve a claim notice were on, say, an equitable owner were fatal, and I accept it's not. But while it affects the strength of my argument, I say it's still strong enough. Because what would happen if the court were to hold that equitable interests are covered is that the RTM company would still have to undertake inquiries because it could not be confident before it serves the claim notice that it will be okay on the Nugee or A1 Properties analysis. It all depends on whether it ultimately wins in respect of the landlord which it has served. But before that, the landlord would take the point, you didn't serve this other landlord. That would have to be fought out in the FTT. That's one point. My second point is this. I mean, maybe it's not a good point, but I'll make it for whatever it's worth. The Supreme Court decision, it marks a very significant change to what the law was, which was Elam Court. So my argument would have been much stronger when Elam Court was the law. But when one has to ask, what did Parliament intend in 2002 when we didn't have Elam Court, we didn't have A1 Properties? Did Parliament intend that you can only do this, you can only start this procedure once you have taken whatever inquiries may be needed to find out who has equitable interests you don't even know about? And the answer to that is very unlikely to be yes, because that's not, you can't reconcile that with Parliament's stated objective of keeping this simple and inexpensive. Because I can...
Parliament did make provision for cases where the landlord couldn't be found or ascertained.
Yes.
So it's not as if Parliament hasn't given some thought to the point you're making, but it's difficult for tenants sometimes to know who the landlords are.
Yes.
Why is that not an answer to your point? I mean, if you look on the register and X Limited appears as the legal owner and you get your demands for service charge from X Limited, if it turns out X Limited is a trustee for Y Limited, but you have no reason to think that that's the case, might it not come within those beneficial provisions which allow you to just not serve someone whose identity can't be ascertained?
Yes, so that's the next point I was going to address, my lord. I think the provision your lordship has in mind is section 79.7.
Yes.
But it's not a complete solution to the problem I'm identifying, because if we go to that, please, page 13, volume 1, page 13.
Yes.
It says, subsection 6 does not require the claim notice to be given to a person who cannot be found or whose identity cannot be ascertained. It doesn't say
make inquiries because you've got to establish that you haven't been able. reasonably to
Yes.
identify them all too.
Precisely so, my lady. And the other point I'd make is it doesn't use the word reasonably. It doesn't say who cannot reasonably be found or whose identity cannot reasonably be ascertained. I mean, there might be an argument, which no doubt a landlord would take, whether that word should be read in. But if the tenant were to lose that argument, then this is a very high bar. And let's posit a case where you know there's a particular landlord because they are registered. You found out they are there, say Millcastle. If Millcastle holds its interest on trust for, I don't know, somebody in the Cayman Islands, you have no way of discovering that. But before you serve the claim notice, you would have to ask Millcastle, do you hold your interest on trust? If they refuse to answer that question, even then you can't be confident you'll be within 79(7) because you've got a right to apply to the county court to compel them to answer. And the landlord might say you've got to do that before you can serve. And that's, I think, section 107. It might have been different if it had said, take such reasonable steps. But even then, there'd be scope for argument. And what if the person in the Cayman Islands in turn holds on a trust for somebody else? What if there's a chain of trustees?
And that's not out with possibility, is it, given the huge corporate structures we have and offshore asphalts and so on?
Indeed, my lady, I respectfully agree. And I don't in any way seek to criticize that. People do it.
No, I mean, that's
just the way it is.
an accepted way of commerce.
And often for tax reasons, for perfectly legitimate tax reasons. But if an RTM company doesn't do all of these things, ask every legal owner you know about. Then if they tell you, ask every equitable owner whether you in turn hold on trust. If they don't tell you, go to the county court under section 107. Unless you do all that, you're not going to be within 79(7). You're going to end up having this argument about Elim Court and Avon Properties in the FTT. So there'd be an Avon Properties analysis in every single FTT case because it's fact sensitive. It all turns on prejudice. Avon Properties, it all turns on prejudice, but that is inevitably fact sensitive. So the one thing that would be guaranteed, or at least very likely, if the word landlord includes equitable owners, is more litigation, which is the opposite of what Parliament intended. And put another way, there's no good reason for extending landlord to include equitable owners if there is already a legal owner. Because one can see what Judge Cooke was getting at in Cresta. If the only person with a relevant interest has an equitable interest, then if you say they don't count, there's a problem. Because, for instance, you could then ignore the interests of that relevant flat. But you don't have that problem in cases where you've got both a legal and an equitable interest. And consistently with the approach the courts adopt to property legislation generally, we say that it should not extend to equitable owners. Now, I'm mindful I should leave enough time for my learned friend to reply. So can I just make two brief points? My learned friends take 4 points in response to everything I've said. I've addressed it in my reply skeleton. So unless the court would like me to address this, I wasn't proposing to do it. It's addressed in paras 31 to 38 of my reply skeleton. I mean, the only thing I should say perhaps is they say people who have management functions should fall within landlords. And they say, we have management functions, why don't we count? But that's a false point because the touchstone in 79 and 88 is whether you're a landlord, not whether you have management functions. And we actually know that some people who have management functions are not landlords, say a manager appointed under Part 2 of the 1987 Act, who's identified separately in 79(6)(c), so they're not a landlord. We also know that people who do not have management responsibilities can be landlords. So let's take a case where you are the registered proprietor and you appoint a manager under the 1987 Act. You haven't got anything to do with management, but you're a landlord because you're the legal owner. So it's a false connection to say that if you have management functions, then you're a landlord. But the other points are addressed in my reply skeleton, and I wasn't going to go back to it, including the section 112 point, which doesn't really assist because the context doesn't permit. Otherwise, even if it did, it's concerned with cases where there's only an equitable owner. The only other point I need to make is a correction. My Lord Justice Nugee asked me yesterday whether the employer in the Globe Elastic case could have recovered the money that had been awarded to the workman by the Industrial Tribunal. And I said at the time, the employer may have been able to bring an unjust enrichment claim because the Industrial Tribunal's decision was a nullity. But thinking about it overnight, I don't think that's actually right because in Globe Elastic, the employer had entered into a contract to pay additional bonuses to Mr. Vijayashko for the remainder of the 15 years. So if the employer had brought a claim in unjust enrichment on the ground that the decision of the industrial tribunal is a nullity, the employer would have had to do that in the ordinary civil courts, and the workman would have had an unanswerable defense, which is even though the industrial tribunal's decision is a nullity, it's ought to be under a separate contract. And that may be why it didn't happen, but I just wanted to correct that because I think the answer I gave yesterday was wrong.
Thank you.
So there was no dispute that Global Elastic had properly paid the employee. The question was whether it was paid under the Act.
Precisely so, my lord. And that,
Because it was only if it was paid under the Act to be entitled to get the rebate from the Secretary of State.
precisely. And the reason why it's a case which we submit supports us is it demonstrates that if you make a payment by reason only of an estoppel, it is not a payment made under the Act, and the tribunal doesn't have jurisdiction. And that's sufficient for my purposes.
Yes. Thank you.
So I'm very grateful to the court for giving me extra time, but unless there are any other points with which I can assist, those are my submissions.
Thank you very much indeed.
Grateful.
Yes, Mr. Bates, anything in reply?
Yes, only on the respondent's notice and only new points, of course, in the proper way. And we will definitely finish before the short adjournment. Can I start where my learned friend ended, going through the difficulties that he says in identifying people, the in terrorum problems that might arise if we include equitable landlord within the concept of landlord? And can I answer that by coming back to where I started my submissions yesterday and making the point of just how narrow this case is? And what do I mean by that? I mean, it's important to remember on the facts of this case, they have already found us. Whatever hypothetical difficulties there might exist in other cases, they didn't arise here. And the result of the A1 case, I would suggest, is that many of those hypothetical difficulties fall away. That's the beauty of the void-voidable distinction. The genuinely undiscoverable landlord sitting offshore, existing for the sole purpose of collecting a ground rent stream, is likely to find its challenge very difficult to maintain after A1 properties. You also see, respectfully, the difficulty in what my learned friend was submitting when you look at the actual wording of section 88. Because it has to be costs, you're only liable for costs in consequence of a claim notice given by the company. So it assumes you've been found and you've been given that claim notice. This is another example of why we started yesterday by emphasising the narrowness of it. On the facts it was very narrow, and actually on the Act it's narrow. You have been found and you have been given that claim notice.
But you're not suggesting that the concept of landlord should mean something different in section 88 to other provisions, are you?
So let me be clear on that if I haven't already. I actually say the critical provision is 79.6. That's the landlords who are entitled to get the claim notice. That's the same, well, the three entities, sorry, who are entitled to collect and receive the claim notice. What matters is, are we a landlord for 79.6 purposes? Because if we are, the Act then follows through and we fall within section 88. That's why I said don't introduce in the respondent's notice yesterday before handing over to Ms Gibson. That's why I say our position is they were right to serve us, because we are a landlord to whom section 79.6 applies.
My point is that if you're maintaining, as you are in the respondent's notice, that landlord therefore includes a landlord in equity under section 79.6, it's quite tricky to just invite us to look at the words of section 88 and say, well, they found us. We've got to look at the implications of this decision beyond the facts.
I accept that, but that's where A1 in my submission actually provides an awful lot, perhaps even all of the answer. It's that void-voidable distinction. That's going to be how landlords are discouraged from trying to take technical points for the pure purpose of defeating claims where they have no substantive benefit. A1 protects against that. But can I just then turn to pick on some of the other points my learned friend made? My learned friend spent quite some time criticising the evidential position, and there are 2 points I want to draw out in respect of this. The first, a relatively narrow one, the second perhaps more important. My learned friend's criticisms focus largely, in fact even entirely I would suggest, on how my client presented its evidence in the FTT in the costs claim. But respectfully I say you have to read what we said in the costs claim against the pleadings in the underlying claim. Our application for costs only arises factually in this case because the original underlying claim was dismissed. So it's artificial to separate out what's said in the Section 88 pleadings from what was said in the Section 84 pleadings. The reason very little is said about it by us is precisely because for all the reasons we canvassed on the substantive appeal, we say it was common ground, that we were a landlord. The perhaps broader point I need to respond to, my learned friend, he suggests that what we're doing here is taking a new point. Can we just look very carefully at how what's the 2 respondents' notice points, what's grounds 2 and 3 below, came into being? Because it's not quite as clear as my learned friend suggests. Can we go in the main bundle to page 88, which is behind tab 7, it's Judge Cooke's decision. And the critical paragraph is paragraph 12, and what you'll see there is it was the tribunal below, the FTT, who granted permission to appeal on all 3 points. So this wasn't a new point being taken in the Upper Tribunal. My client below in the FTT had taken the estoppel point and had lost on that. It then applies for permission to appeal, taking these 2 additional points, and the FTT grants permission. I say this with all the appropriate respect and deference I can manage. Having got permission on it, we're entitled to a decision on those arguments. This isn't a sing and das new point. I'm not coming to you or to Judge Cooke saying I'm raising a brand new point, please can I have permission? I have permission.
I think it's settled that even if you have permission, it doesn't stop the respondent saying this is a new point and hence sing and dance and so on. That's why the issue is, indeed that's why the issue is considered so often.
Yeah, I would accept that. I can't simply pray and aid the FTT's permission and say I get home. But in terms of framing this debate, the position was put to the FTT purely on estoppel, and we lost.
Yeah.
At that stage, we then seek permission to appeal, and we say, well, we have estoppel, or if you don't like that, we have 2 other arguments regarding in substance that we are the landlord. The FTT says, I'll give you permission on all 3 of those. So it knows that the second and third arguments are brand new. It must know that, because it was determining the case, but nonetheless it thinks it appropriate to give permission. The Upper Tribunal simply does nothing on those second and third arguments. There's an application for disclosure, as my learned friend says, and it's parked because Judge Cooke takes the view that issue 1 might be determinative. The reason we have to put it in a respondent's notice here is because we've never had the opportunity to have the argument about those 2 points, either substantively or my lady's point, to respond to the argument, this is all new, why didn't you do this below? It was envisaged this would be done in the Upper Tribunal, and it wasn't. Had we said nothing about it here, and had you ruled against me on the appeal, no one would have given me any hope of then jumping up at the end of the hearing and saying, please could you nonetheless remit, because there are these 2 issues that haven't been determined.
But you're not inviting us to remit. You've put your case throughout on the basis that Assethold is the equitable owner, and that parked application does not need to be dealt with.
Quite, and I don't resolve it now, and I'll come on to that in a moment now as to why we say that's still right. But it's not quite as simple as just as this is the wholly new point arrangements. The FTT knew it was new, granted permission, And one thing I did wonder, but you're right, my lady, I'm not inviting you to do this, but one thing I did wonder is whether the court might nonetheless conclude that that was the appropriate answer, is remit that back to Judge Cooke to decide what she wants to do about the parked application. I don't say you need to do that, because I say we can win on our respondent's notice. But it wouldn't be right of me to leave the impression this is a wholly new point that we came up with for the first time in this court. The reason why I'm not positively inviting you to remit is because we do maintain our line that what we have is enough. I won't take you back through the FTT decision. You've been through it with my learned friend. You heard me on it originally. We say there's enough in there. And we do say that our position is bolstered by what Judge Cooke decided in Cresta. Now, of course, not binding upon you. But the points we asked you to take from Cresta, I'll give you references rather than anything else. But the first bit we looked at yesterday, Judge Cooke's analysis as to why an equitable tenant is nonetheless a tenant holds equally true in our view for whether an equitable landlord is enough. That's a different question from who has to be in receipt of a notice. This is about whether we fall within the definitional provision in section 79.6, not whether there was actually a clever argument open to them that they didn't have to serve us in the first place, because they did serve us and they chose to serve us. And secondly, the 7 Sunny Gardens case that my learned friend took you to, we say Judge Cooke deals with that, and I'll give you the reference, it's paragraph 60 of the Cresta Court decision. The critical thing about 7 Sunny Gardens was there'd never been any separation of the equitable and legal estates. There was only ever one person it could be. So that's why she explains, the Deputy President says, well, in 7 Sunny, the Deputy President says, well, there's no need to look at the position with regards to beneficial interests. It just didn't arise on its facts. Counsel for the RTM Company in 7 Sunny Gardens makes the submissions that my learned friend makes, and Judge Cooke explains why 7 Sunny Gardens isn't authority for the proposition.
Sorry, you said Cresta 60, did you?
Cresta at paragraph 60, yes. But the other point I asked you to take from Cresta in response to something my learned friend said, it's Cresta at 55. Judge Cooke is quite content that the equitable tenant is a qualifying tenant, not because of arguments about whether or not Section 2 of the 89 Act has been complied with, etc. It's registration gap, that's enough. That's Judge Cooke's point. How you get into that registration gap doesn't matter. And that's her paragraph 55.
We touched on this yesterday with Ms. Gibson. How is it that if you're not relying on there being a specifically enforceable contract which complies with Section 2, how is it that just because you're in the registration gap, you get the equitable interest?
So you have the equitable interest by virtue of the contract for sale, we say.
You complete the contract by paying your money and you get a TR1 and you lodge it at the land registry. Is your equitable interest which you have then still dependent on the contract, or is it, do you get a different equitable interest because you've got a completed conveyance or because you've lodged it for registration? I'm still not quite sure what the analysis is.
The answer is I'm not sure it matters.
Right.
Because once, and again, this is, to come back to it, a theme I've been repeating, this is the narrowness of our submissions. On the facts of the case, we've purchased it. It doesn't really matter how you analyse this, whether you analyse it as, one scenario, I thought my lady Falk was going to put down a friend. I mean, you could even start to get into the cases about, is it a purchase money trust? Is that the situation?
Well, those are the sorts of
that's where I wondered where you were going, where you were going.
There is a different type of trust.
Why? It's
once the money's paid.
Yes. It doesn't really matter. The position is, and the position as was plainly understood by the RTM company because they served us with a claim notice, the position is that we had an interest. that interest, we say, was enough to fall within section 79.6. We do say we were legally obliged to perform all of the functions that were due under the leases. That's the RM residential case. Judge Cooke explains it. Interestingly, in RM residential, she doesn't analyse.
Is that based on the 1995 Act?
No, it seems to us she does it based on the fact there's just a trust.
But that doesn't work. If you leave aside registration gaps, contracts, and assignments, and all that, if I'm simply the legal owner of property of the reversion, and I declare myself a trustee for somebody else, they don't become liable on the contract, on the covenants.
The 1995 Act has that effect for leases within it.
But only on assignment. And again, if you have a contract to assign, which is uncompleted, but the money is paid over, in many senses, the vendor does become a bare trustee. The person doesn't get an assignment because there's no bit of paper. So you can't just equate being the equitable owner with being liable on the covenants under the 95 Act. The two are not coterminous.
I accept that, and I'm very, very conscious to try and keep this submission as narrow as I possibly can. Precisely because what we're looking at here is what does the landlord in section 79.6 mean in this act? That's why when I started my substantive submissions, I see my lady pulling her face, so I'll try and make this as clear as I can. It's why when I started
I'm following.
It's why when I started my substantive submissions.
Did landlord once.
It's why when I started my substantive submissions, I started by going to A1 Properties and paragraph 67, where the Supreme Court identified that what's happening here is a complicated contractual arrangement for day-to-day management of building. It's moving from A to B. That's what we're doing. We're facilitating that transfer from A to B. Who is the person whose functions are being interfered with? Well, we say it's us. What's section 79.6 trying to do? You heard me on that yesterday. It's trying to make sure that those categories of people, who are the three categories of people who are most likely to be doing the management, know what's going on. I can't overemphasize the narrowness of our case. I am not suggesting, and I'm not inviting you to make law, but landlord for all purposes in all statutes will mean equitable landlord. I'm inviting you to say that on this particular scheme and on these particular facts, we fell within section 79.6. And if that's right, they were right to serve us, and therefore we are entitled to the benefit of section 88.1. One other very short point on the A1 Properties case. My learned friend took you, if we can go in the authorities bundle, at tab 10, page 123. Took you to the passage from the consultation paper, stressing the need for the procedure to be as simple as possible, etc., etc. What he didn't take you to, in my respectful submission, and this is important, is the last sentence of the consultation paper, because this is making the point I've been trying to make to you. At the same time, the legitimate interests of the landlord in the property should be properly recognised and safeguarded. Well, what are those legitimate interests? Well, you know from section 79.6 and from section 96. It's to make sure that they know that they're going to have to stop doing the cleaning, doing the repairs, doing the roof repair, etc. That's why that category of 79.6 people is identified, because they're the ones who do those things. That is the driver for the very narrow interpretation we take under this Act as to whether or not we fall within section 79.6. Just checking my notes for a moment. ladies, my lords, unless anybody have any further assistance. It just reminds me for one final point, to thank my
Certainly.
learned friends, of course, for appearing pro bono, because they were both good enough to do so, and I'm sure that the court, and certainly on this side, were very grateful.
Anything else? Anything else? Well, thank you all very much indeed. I, of course, repeat our considerable gratitude to all the very hard work that's been done by the appellants, the whole of the appellant team. We're very grateful. It's been done with considerable expertise, and I think we're all extremely conscious of the enormous amount of work that has gone into the preparation of the case. So thank you on behalf of all three of us. You won't be surprised to hear that we're going to reserve our judgments. I'm not quite sure how long that will be. Obviously, we haven't had our discussions yet. They'll go out in the normal way in draft. That, as you're well aware, is for typographical and other minor errors and not an opportunity to re-argue any points, even if you've thought of even better ones in the meantime. Please remember the terms of the embargo that appear on the top of the draft, and ensure particularly, as I've noticed, you haven't got instructing solicitors with